I've got one that can see.
He's a tall, Caucasian male that doesn't appear armed, wearing sunglasses.
I don't like this one bit. Not one bit.
That these individuals are obviously related to the dynasties of old. Father George and his wife Barbara are both descendants of Godefroy de Bouillon, who in 1099 was leading European noblemen in a successful crusade to recapture Jerusalem from the Islamic faith and moved into the king's palace there at Temple Mount. And Godefroy was the first king of Jerusalem and the Duke of Lower Lorraine, a major region of the Illuminati bloodline.
The genealogy shows that I'm descended from Vlad the Impaler. So I do have a bit of a stake in it.
As it were.
Bush is closely related to every European monarch on and off the throne and has kinship with every member of Britain's royal family, the House of Windsor. He's related to her daughter, Queen Elizabeth.
Not my queen.
So, want to know who's behind Bush? There it is. And he is 13th cousin once removed from the heir of the throne, Prince Charles. These are oligarchs. These are aristocrats. And of course, because of the wars and the rise of rebellion, they can't operate openly anymore from the throne and hang people in the streets like they used to do in my country, where a nobleman, the Lord, would literally stand on his balcony and watch the rebels be hung, drawn, and quartered. They know if they try that, they'll be overthrown. So they change tactics just a little bit and put people that are officially not known to be related to them in power.
Okay, so welcome to the presentation. So this presentation is about sovereignty. What is sovereignty? So we can look at a case site right here, American Banana Company versus United Fruit Company. The very meaning of sovereignty is that the decree of the sovereign makes law. So it sounds pretty straightforward.
Queen, Taramis.
Not my queen.
So this is Black's Law Dictionary. Sovereignty, the supreme, absolute, and uncontrollable power by which any independent state is governed, supreme political authority, paramount control of the constitution and frame of government and its administration, the self-sufficient source of political power from which all specific political powers are derived, the international independence of a state, combined with the right and power of regulating its internal affairs without foreign dictation, also a political society or state which is sovereign and independent. That's Chisholm versus Georgia, which is an important case, and we'll get to that. Then it goes on to say the power to do everything in a state without accountability, to make laws, to execute and to apply them, to impose and collect taxes and levy contributions and make war or peace, to form treaties of alliance or of commerce with foreign nations and the like. Now I want you to bear in mind when it says anything without accountability, you know, when it comes to, say, murder, for example, they have wars, they come through and murder people, you know, it just depends on how it's framed. Now, when it comes to individual sovereignty, you have to respect other people because everyone is sovereign. We're all kings and queens. So if you impinge on someone else's sovereignty, then lawful jurisdiction can be obtained over you. You know, to impose some sort of consequence there, so just bear that in mind.
Lansing versus Smith, the sovereignty of the people.
So the people of the state, as the successors of its former sovereign, are entitled to all the rights which formerly belonged to the king by his prerogative. Lansing versus Smith, one of the most famous cases out there. So a right that belongs to the king by his prerogative, in other words, you want to know what the king's rights are, ask the king, he'll tell you. You understand? The king basically, you know, he defines his own rights. They don't need a Bill of Rights or a constitution or anything else to define our rights. Another very famous case is Chisholm versus Georgia. At the Revolution, the sovereignty devolved on the people, and they are truly the sovereigns of the country, but they are sovereigns without subjects, with none to govern but themselves. So, just like what you saw in the intro video, the gaslighting, the absolutely insane lying to people, you know, up is down. There's no evidence that cigarettes are bad for your lungs or that Wi-Fi is bad for you or that mRNA injections cause, you know, even what they say in their own papers, they cause pericarditis, myocarditis, blood clots. It's just an example. It's all inversion. It's all the Luciferian religion of inversion. Now, I'm not religious. I'm not going to go into any kind of religious sales pitch. I'm just telling you they are. So, what is the fundamental, foundational definition of Republican government? It's about one paragraph. One in which the powers of sovereignty are vested in the people and are exercised by the people either directly or through representatives chosen by the people to whom those powers are specially delegated. So there you have it, folks. And that's Black's Law Dictionary, 5th edition. I don't have the page here. It looks like 640 in my screenshot here. Just look it up.
In a republic, the people are sovereign. Look it up.
Don't mind the gibberish of the AI wording there. Okay, so I want to present an example to you. This is an ongoing case. One of the county corporations, and their corporations, I'll show you a snapshot of that here in a few slides, was trying to come at me with some egregious, unconstitutional, and extraordinary attack. And I filed a counterclaim against them, which is one of the things that you do to challenge their jurisdiction, aka their sovereignty over you, especially when there's no victim involved. Okay, and this is an excerpt from a brief that a guy named Josh Kaul, who is the Attorney General of Wisconsin currently, and if you research him, he's currently fighting with all his might to keep the unmonitored ballot boxes open, to release all the abortion regulations and statutes, to completely open the door to any atrocity you can imagine. And believe me, I get 100% that defining what a woman cannot do with her body is also government overreach. I mean, I've been on marches for that decades ago. But when you learn that Planned Parenthood and them are selling the aborted fetal organs, you understand the people who are making the most noise about this couldn't give a rat's tail about human rights or people's rights. And, they're not going to all this trouble to make things convenient for the average citizen. So this is one of the arguments of Josh Kaul against my claim, which nowhere do I ever, nor should you ever, use the term sovereign citizen. A citizen is a subject of the sovereignty. Okay, I'll get to that. I want to point out how, just like I said, how blatantly they are with the gaslighting. It's absolutely laughable. Now, this is about the 4th time that this Josh Kaul fellow has come up against me. And keep in mind, we're not asking their magistrates to rule in my favor. That's the whole principle of this. Anyway, we'll get to that. So in the same sentence as he accuses me of making frivolous sovereign citizen arguments by raising issues like the foundational principle of a republic is that the people are sovereign, as I just showed you in the dictionary. But in the very next word of his sentence, he claims that they have sovereign immunity. You understand? So the government does have a clipped sovereignty. They have derivative immunity, judicial immunity, sovereign immunity in the act of their official duties. But as soon as they exceed their jurisdiction, they're acting ultra virus outside the constitutionally defined spheres of their duties, and they no longer have that immunity. Okay, now they're going to argue that with you. They're going to tell you anything, they'll argue anything with you, no matter how ridiculous. But in the very same sentence, it's like a little child saying, oh, you're not sovereign. We're sovereign, though. It's totally out of control, and this is why we're here. So our revolution broke up the foundations of sovereignty and government, and our written constitutions have carefully guarded against the baneful influence of such an idea henceforth and forever. That's Gaines versus Buford. Now, this is out of Kentucky, and they will make the statutory argument, well, that has no standing in California or Wisconsin or wherever you are. But you'll get to understand this. We're not citing these cases. We're actually decreeing them. Now, again, you must study these things before you just walk in and start saying, I'm sovereign. Don't ever say you're sovereign. Just say you're one of the people. That's all you have to say. And don't walk in and say, I'm going to decree this or that. Put it in your paperwork, but don't say it. And stay humble, be polite, be respectful. And is a kind of a code of conduct here. There definitely is, but this is a perfect quote right here. So this is another excerpt where he, again, in the same sentence, claims that anything you mention about the sovereignty of the people are frivolous sovereign citizen arguments. That's a term they invented to demonize people who assert their rights, just like conspiracy theorist. You know, and this Josh Call guy, he'll go right and claim that Trump is making baseless, conspiracy theory statements about the unmonitored ballot boxes not being safe. Okay, and that's one of their main goals right now. And Evers has filed a brief, or some of his attorneys in his behalf, that's the governor of Wisconsin, has filed a brief in support of trying to overturn the ruling to allow the unmonitored ballot drop boxes. And, you know, I'm sure the only motivation is so he can make things more convenient for the citizens of his realm. Anyway, you see, again, sovereign immunity of Wisconsin. And I want to point this out, what he's claiming here. Again, they have sovereign immunity. It's not the quote I thought it was. It's one where he goes on to say that even if their acts are malicious and corrupt, they still are protected. Doesn't matter. It's insane. So, okay, here is just the first page of this case. The first page of this brief. You can look this up on wicourts.gov. You can download these files. This is Evers arguing to keep the unmonitored ballot drop boxes open. You know, again, you can speculate on that.
Not today, Your Excellency.
And that's their official title. The governor's official title is Your Excellency. You can look that up too. So Alexander Hamilton wrote, "One cornerstone of Republican government was the prohibition of titles of nobility. The Federalist Papers, the Federal Constitution crafters defined republic simply as a government where the people are sovereign, not less, but certainly not more." Now this is an excerpt from a page here out of the European definitions of the royalty. Again, they're using the term His Excellency for governors. This is right off Wikipedia. In Republican states, they refer to them as His or Her Excellency. So completely countermanding the concept of no bills of attainder, no ex post facto law, and no titles of nobility in government shall be granted. Okay? Yet they're going around purporting excellency and purporting sovereignty over us as their subjects. This is it right here. This is a quote that Call cited against me. "A public prosecutor acting in their official capacity is absolutely privileged to initiate or continue criminal proceedings and is exempt from civil liability, irrespective of even malice or corrupt motives." Well, this is what they're claiming. They're claiming you're a subject. You know, if they decide to do anything they want, they are exempt even from what they call equitable remedy, which is a civil lawsuit against them, much less criminal charges. I'd like to point out that the warden of one of the prisons here in Wisconsin, of which there are like 30 prisons, I think, in Wisconsin, it was like 35 actually, was arrested, and some of his thugs were arrested along with him, and he was charged with murder. That was in the last year. Then, of course, there was that magistrate, more commonly referred to as a judge, who was arrested here in Wisconsin for interfering with ICE. And, you know, I know the ICE thing is controversial because, you know, your average people that want to come into this country and work, you know, is a total different ballgame than, you know, human trafficking. But regardless, she interfered with ICE and they arrested her. She tried to have it dismissed. They said, no, it's going forward. So that's really good to see, you know, because that means that, you know, the message is being sent by someone, whoever's behind that they are not impervious and immune to any consequence for their corrupt and malicious actions. So now I want to talk a little bit about what sovereignty is not, or what they're purporting sovereignty over, and that is the citizens. So this is right out of the 14th Amendment. A citizen is all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. So I'm going to cite parens patria here, and we'll come back to that. Latin for parent of the people is a doctrine in which a state or court has a parental relationship over and a protective role toward the citizens or others subject to its jurisdiction. Now, dig this quote right here. "The people of Maine, in the exercise of their sovereign powers," okay, the people in their sovereign power, have conferred citizenship on those of African descent. Okay, so when they created the 14th Amendment, they didn't free anyone, I mean, in the real legal sense. What happened was they transferred the slaves into public ownership. And then what was supposed to happen is as soon as the slaves had a child, that child was supposed to have the full rights of one of the people. But instead, they're trying to make all of us classified as a citizen, which is a freed slave, basically. Now, pay attention. I'll keep going with this. So here again is the 14th Amendment cite. Now, as Chief Justice Marshall explained, an exercise of jurisdiction is an exercise of sovereignty. So, all persons born or naturalized in the United States and subject to the jurisdiction thereof, subject to the sovereignty, are citizens. They're subjects of the sovereignty. And whenever you walk into a courtroom, they're going to presume that you're a citizen, not one of the people. And if you don't object, it means that you agree. You're dishonoring the presentment, you're tacitly complying, you're tacitly agreeing and entering into the contract to allow them to treat you as such. You're acquiescing through your failure to object in the proper way. And even if you object orally, you want to file paperwork because words are ethereal. Now here's a little bit more on the citizen thing. This is a really good site here too. Both of these are. Now allegiance is nothing more than the tie or duty of obedience of a subject to the sovereign under whose protection he is. Remember, he means male or female in legal English. And allegiance by birth is that which arises from being born within the dominions and under the protection of a particular sovereign. Two things usually occur to create citizenship. First, birth locally within the dominions of the sovereign, and secondly, birth within the protection and obedience, or in other words, within the allegiance of the sovereign. That is, the party must be born within a place where the sovereign is at the time in full possession and exercise of his power, and the party must also at his birth derive protection from and consequently owe obedience or allegiance to the sovereign as such de facto. The rule commonly laid down in the books is that every person who is born within the allegiance of the sovereign is a subject. Okay, the people are not subject. A subject is property of the sovereignty, like a subject of the king or the queen. So that is a cite from English v. Trustees of Sailor Snug Harbor, United States Supreme Court, 1830. Now in Black's Law Dictionary, 4th edition, we look up the meaning of the word allegiance. Allegiance, the faithful obedience of a subject to his sovereign, comma, of a citizen to his government. Okay, also all derivatively the territory of a state or sovereignty, but that's inconsequential, that part of that quote.
Not my queen.
Sovereignty itself, of course, is not subject to law, for it is the author and source of law. But in our system, while sovereign powers are delegated to the agencies of government, sovereignty itself remains with the people, by whom and for all government exists and acts, and the law is the definition and limitation of power. Yickwo versus Hopkins, United States Supreme Court. So I'm going to help you understand sovereignty by these sites. You should build some good neural pathways based around these various sites and definitions. The immunity of a truly independent sovereign from suit in its own course has been enjoyed as a matter of absolute right for centuries. Only the sovereign's own consent could qualify the absolute character of that immunity. And first, the law ascribes to the king the attribute of sovereignty, or preeminence. Hence it is that no suit or action can be brought against the king, even in civil matters, because no court can have jurisdiction over him, sovereignty over him, for all jurisdiction implies superiority of power. And that's coming from something called Blackstone's Commentaries, something you should familiarize yourself with if you want to learn this subject. And that is Alden versus Maine, also U.S. Supreme Court. So you understand, whenever you try to sue a DA, whenever you sue a DA, and actually a suit is in equity, you take an action is at law. Whenever you file an action against a DA or any public official, a cop or a deputy or a magistrate, they're going to immediately complain or going to claim a couple things. They're going to say, first, the plaintiff failed to state a claim upon which relief can be granted. Then they're going to say, we're sovereign. You can't sue us. We're sovereign. You have to get our permission, to sue us. We have to approve that you can even take action against us. Okay, so they are claiming this attribute of the king, when in reality the people are the kings and queens of this country. Again, that's the fundamental definition. You know that. So this here has to do with our kids particularly. And I started studying this about 10 years ago, but I really accelerated when I started messing after I had a divorce, and I started to experience some serious issues with, guardianship, which is a BS term too, by the way. Anyway, now dig this. This doesn't make your blood curdle, check your pulse. The theory upon which the court proceeds in such cases is that the custody and control of the parent over his minor children is a trust committed to him by the state, which should more properly be said the government, because the state is the assemblage of the people. The people are the state. The government are the agencies, the CPS and them. And this trust is dominated by the supreme guardianship of the state as parens patria of all infants within its border. And when the parent abuses the trust so as to endanger the welfare of the child in such sort as to hamper or retard its development into a good citizen, okay, the interest of society requires that the government to assert its supreme guardianship and protect its ward. So just in case you missed that, a government claiming our kids are their ward from the very beginning. I mean, these are the kinds of words that bloody revolutions have been fought over, okay? People didn't, die in these revolutionary wars to have these entities claim that our kids are their wards. That's why I come back to the parens patria thing. They say supreme guardianship as parens patria. Now, if you pay attention to that quote, one of the first quotes in here, that the people are entitled to all the rights which formerly belonged to the king by his prerogative. So parens patria was something that the king used to assert over his subjects. So the people have the right of the parens patria, not the government. Now, of course, I'm talking about fit parents here. I'm not talking about parents who are, smoking crack or beating their kids by any stretch of the imagination. I'm talking parents, who are fit parents. And by the way, the best interest of the child standard is one of the most abused things. So, it needs to be proven by due process of law, which goes back to the Magna Carta, and I won't go into that right now, but you get where I'm going. It needs to be a good reason.
Not my queen.
It'll break up the monotony a little bit. Okay, so what is a court? The person in suit of the sovereign, the place where the sovereign sojourns with his regal retinue, wherever that may be. Okay, you ever thought about what a court actually is? Think about propaganda. Think about every TV show you've ever watched is giving you the idea that magistrate is the ruler, is in charge. Okay, court, an agency of the sovereign created by it directly or indirectly under its authority, consisting of one or more officers, established and maintained for the purpose of hearing and determining issues of law and fact regarding legal rights and alleged violations thereof, and of applying sanctions of the law, authorized to exercise its powers in the course of law at times and places previously determined by lawful authority. Yeah, that's Black's Law Dictionary, 4th edition. The first one's 5th edition. You get the idea. That's what a court actually is. If you say, I'm going to court, and it's also supposed to be a court of record. Another quote here I found actually recently, which I like. A court is an instrumentality of sovereignty, the repository of its judicial power, with authority to adjudge as to the rights of persons or property between adversaries. So, once again, it's all gaslighting you into thinking that you are a subject, they have sovereign immunity. How dare you challenge any of these egregious, unconstitutional, disgusting, despicable acts that these DAs, engage in every single day. And anything they do that is not lawful, like as in common law, in the Constitution it says law or equity. Statutes are equity, law is common law, inferior courts are proceeding according to special or limited jurisdiction, which is proceeding according to statutes. Common law courts are superior courts. And I'll make a video about that, but I have a few sites about that later. So the Magna Carta was one of the first times that people actually had rights. The year 1215.org it was written. You can look up some history about that. But here's Article 34. Henceforth the writ which is called precipice shall not be served on anyone for any holding so as to cause a free man to lose his court. Okay? That's Magna Carta. And now here is an example of how Magna Carta is still good. It is. If you just search Magna Carta on a case site website, they quote Magna Carta hundreds, if not thousands of times in controlling cases. So Now dig this quote. Our justices, sheriffs, mayors, and other ministers, which under us have the laws of our land to guide, shall allow the said charters pleaded before them in all judgments, in judgments in all their points. That is to wit, the great charter as the common law. So bureaucrats need things in writing. They want to know what the common law actually is. Common law is not case law. That's a little piece of it. It's whatever the people decide it is. However, you can decree that the Great Charter, which is what Magna Carta means, Great Charter, as the common law, is the common law if you choose it. Confirmatu Cartarum is the confirming charter that was put out years later, looks like 1297, I don't have that date memorized. And this site comes from Sources of Liberties, an American Bar Foundation book of all places. This is what the attorneys, join up with, the Bar Association. So you get the idea of what a court is here, where I'm going with this. Now, what is a court of record? So all courts in the country are supposed to be courts of record. To be a court of record, I'm not going to read the whole thing here because it's not all relevant. The two key points here are, it's proceeding according to the course of common law. That's what a court of record is. Every time you go into court, they're going to start citing statutes and ordinances and codes, etc., penal codes, etc. That's not common law. It's not. It's basically the opposite of common law. Essentially, the common law comes from the English common law. The statutes come from the Roman civil law. And the common law is the law of the people. The statutes are the policy of the special interests. That's a pretty good way to put it. And then the number two super key point here is that it is a tribunal, judicial tribunal, having attributes and exercising functions independently of the person of the magistrate, designated generally to hold it. Okay, a magistrate is what they call a judge. He's the guy or girl on the bench. So in a court of record, the tribunal is independent from the magistrate. Now, and to take some time to wrap your head around this, that means that the magistrate does not make decisions in a court of record. So when you're the plaintiff in a court of record, you are acting in your sovereign capacity. Now, this is going to be an uphill battle. Almost no attorney you ever talk to is going to believe you. There it is in black and white. Now here's the Supreme Court, U.S. Supreme Court case. The judgment of a court of record, whose jurisdiction is final, is as conclusive on all the world as the judgment of this court would be. It is as conclusive in this court as it is on other courts. It puts an end to inquiry into the fact by deciding it. So this is the United States Supreme Court speaking, saying that a court of record is as conclusive on all the world as one of their rulings is. And then it says it's as conclusive on them, on this court, meaning the Supreme Court, as it is on other courts. Okay? Once again, the very meaning of sovereignty is that the decree of the sovereign makes law. As I said, there's a whole lot of code of conduct here. Gotta be respectful when you go into court, and you can't hurt anyone. Otherwise, they can lawfully obtain jurisdiction over you. So it's not going to work if you're out there stirring up, some crap. But this is the truth. The government is an agent, and within the sphere of the agency, a perfect representative. But outside of that, it is a lawless usurpation. The mandate of the state affords no justification for the invasion of rights secured by the Constitution of the United States. Otherwise, that Constitution would not be the supreme law of the land.
Poindexter versus Greenhow. Not today, Your Excellency.
And that was Poindexter versus Greenhow, U.S. Supreme Court.
Not my queen.
So as I said before, any act that they perform that is not lawful is not the word or deed of the state. So that which therefore is unlawful because made so by the supreme law, the Constitution of the United States, is not the word or deed of the state, but is the mere wrong and trespass of those individual persons who falsely speak and act in its name. So how many examples can you think of where they violate the Constitution and claim to be acting in the name of the state? Like about, 60, 70, 80% of what they do? The sovereign, like any other principal, cannot authorize its agent to violate the law, so that when the agent does so, he cannot be acting for the sovereign. Now, even with all the gaslighting, they do not deny that they derive their power from the people. They just basically claim that we've given all our rights to them. They want to assert that we've essentially signed away all of our rights to various adhesion contracts, driver's licenses, birth certificates, social security agreements, etc. So bear in mind, there's a case coming up here. It's called Marion et al. Versus Jicarilla Apache Tribe, where it says just because a sovereign does, U.S. Supreme Court, just because a sovereign does not expressly reserve one of its sovereign rights when entering into a commercial contract does not mean that he waives the right. That would turn the concept of sovereignty on its head. So anyone who's ever told you, oh, you signed your rights away when you signed that driver's license, no, not the case. And, you know, like I said, they want to purport that they are sovereign, but the people are actually sovereign. And what I was going to say is that all the statutes in most of the states, they have what's called an enacting clause, or an enabling act. I want to say it's the enacting clause, where at the beginning of the statute, it always says, in the name of the people, we enact this statute. So, I mean, it's in there, but they'll still try to gaslight you no matter what. You know, they could be looking right at, you know, the fact, and they'll say, no, you're not seeing that right now. Look over there, you know, look over here. You know how that works.
Not my queen.
So we already read the Lansing versus Smith. A consequence of this prerogative is the legal ubiquity of the king. This kind of plays off this quote. It says, you know, all the rights which formally belong to the king by his prerogative. A consequence of this prerogative is the legal ubiquity of the king. His majesty in the eye of the law is always present in all his courts, though he cannot personally distribute justice. His judges are the mirror by which the king's image is reflected. That again is the Blackstone's commentaries. The general understanding of republicanism across America at the founding embraced a concept of government in which the people are sovereign, in which the people are consequently the fountain of all power, in which all authority should flow from the people. Okay, that was a Supreme Court case, U.S. Supreme Court. Now here's an example. I'm in Wisconsin right now, and that's where I've been for the last few years, and really dived into this and have been defending myself against all kinds of insidious crap. So here is where it says in the Wisconsin admission to the Union that the Constitution will be Republican. The government will be a Republican form of government. It has nothing to do with Republican versus Democrats, by the way, although it kind of does, because it's not a democracy. Okay, in a democracy, 49% of the people have no rights, and really, when it comes down to it, it's a democracy for the citizens. For the people, it's a republic where statutes are advisory. So, you know, they go on to say, you know, we're on equal footing with the original states in all respects, whatever, etc., that it is a republican form of government. Otherwise, they would not have been accepted into the Union. In America, the people are sovereign. This is the bedrock principle of American government. State versus Roundtree. This is also Wisconsin. There are many sites. You know, I'm just giving you some examples.
Queen Taramis.
Not my queen.
The foundation of our system of government rests in the sovereignty of the people, the Declaration of Independence. This is Wisconsin Supreme Court also. So, I mean, I'm showing you this so you can get a clear handle on this. Anyone who tells you, you mentioned people are sovereign, that, oh, that sounds like sovereign citizen talk. I mean, I've had police, like, they try to give me a ticket for having no, you know, it doesn't matter. I mentioned, you know, the Supreme Court has already said multiple cases that traveling is not a privilege. And just by making that statement, he said to me, well, hey, you know, we're not going to go down the sovereign citizen rabbit hole. I'm like, how does citing the U.S. Supreme Court trigger you to try to lambast and demonize me as being someone who thinks they're a sovereign citizen? You know, that's where they're at. And, you know, all cops aren't bad people or whatever, but they've been trained, you know, to believe this crap. So yes, we ordained and established the Constitution for the United States of America, we the people of the United States. And we never gave up our power to decree more law in the future. Okay, like I said, they want us to believe that the Constitution itself is an adhesion contract where we just gave all of our rights right back over to the government. After that quote I read you, that, our Constitution and revolution, what was the word? Fractured, disintegrated the concepts of sovereignty and government and protected against it henceforth and forever. So, yeah, this is a good site. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage other rights retained by the people. Right? You follow that? It goes back to we have all the rights which formerly belonged to the king by his prerogative. There's no limit to your rights. Like I said, you can't injure another sovereign. You can't hurt anyone. You can't rob anyone, etc. But the Constitution and Bill of Rights do not cannot be construed to deny or disparage other rights. We are now dealing with a written constitution, the original law by which our system of government was set up. It creates the government. By its provisions, the three branches of our government, legislative, executive, and judicial, are created. The three branches of government must look to it for all their power and authority. Not so with the sovereign power, the people. So the concepts here are, yes, the people are sovereign, and one of the key concepts is that, yes, we may act directly. Now, there's millions of people who are going to just laugh in your face and claim you're insane for purporting you can have your own court. I've already read you the definitions, and I've already done this, by the way. And the folks that, have been in this fight have been doing this for decades. And, there has been success. It's not always successful, but there has been success with it. So we'll get into that. The foundational concept of our government is that the people are sovereign and possess all the powers of sovereignty. All political power is inherent in the people, and all free governments are founded on their authority and instituted for their benefit. The faith of the people of Texas stands pledged to the preservation of a republican form of government, one where the people are sovereign, and subject to this limitation only they have at all times the inalienable right to alter, reform, or abolish their government in such manner as they may think expedient. So you get the government is supposed to be instituted for our benefit. Okay, the idea of them putting people into their, preschool to for-profit prison pipeline for possessing a cannabis cigarette, for possessing a joint, or for keeping their own kids for 12 hours beyond when their, would-be sovereign masters say they can or cannot have them, etc. And I'm talking fit parents here, but yeah, no, it's the ultimate inversion. It's the bastardization and just the infiltration of what the country stands for. And people are considered any portion, so you can say a people or many people, singular or plural. However, it should not be forgotten that the people are sovereign, and their constitution is the fundamental law. The Constitution provides, all courts shall be open, and every man for an injury done him in his land, goods, persons, or reputation shall have remedy by due course of law, and right and justice administered without sale, denial, or delay. So, yes, at law there shall be a remedy for every wrong. It is universally conceded that the people are sovereign and that they have power to adopt a constitution and to change their own work at will. Okay? It is an established principle of jurisprudence in all civilized nations that the sovereign cannot be sued in its own courts or in any other without its consent and permission. Alden versus Maine, U.S. Supreme Court. So, again, the ultimate sovereignty is the people.
Not my queen.
But they want to claim that they have that right to immunity from any suit without their permission, but you don't. Okay, that's what they want to claim, because they're claiming you're a subject. And if you don't object, it means you agree. This is an excellent site right here. I do not admit that there is any sovereign power in the literal meaning of the terms to be found anywhere in our systems of government. The people possess, as it regards their governments, a revolutionary sovereign power, but so long as the governments retain which they have instituted to establish justice and to secure the enjoyment of the right of life, liberty, and property, and of pursuing happiness. Sovereign power, or which I take to be the same thing, power without limitation, is nowhere to be found in any branch or department of the government, either state or national, nor indeed in all of them put together. The Constitution of the United States explicitly forbids the passage of a bill of attainder, ex post facto law, or the granting of any title of nobility by the general or state governments.
Not my queen.
I want to say general, it used to be a term for federal. This is an old site. The same instrument likewise limits the power of the general government to those expressly granted, and places many other restrictions upon the power of the state governments. The constitutions of the different states likewise contain many prohibitions and limitations of power. The 10th article of our state constitution, consisting of 28 sections, is made up of restrictions and prohibitions upon legislative and judicial power, and concludes with the emphatic declaration that everything in this article is accepted out of the general powers of government, and shall forever remain inviolate, and that all laws contrary thereto or contrary to this Constitution shall be void. These numerous limitations and restrictions prove that the idea of sovereignty in government was not tolerated by the wise founders of our systems.
The despotic, seditious doctrine is incompatible with our republic and cannot be tolerated.
Now, this is one of the best quotes ever. Sovereign state are Kabbalistic words, not understood by the disciple of liberty who has been instructed in our constitutional schools. Well, guess what? You're on your way to being one of those people right now. It is an inappropriate phrase when applied to an absolute despotism. I firmly believe that the idea of sovereign power in the government of a republic is incompatible with the existence of permanent foundation of civil liberty and the rights of property. The history of man in all ages has shown the necessity of the strongest checks upon power, whether it be exercised by one man, a few, or many. Our revolution broke up the foundations of sovereignty in government, and our written constitutions have carefully guarded against the baneful existence of such an idea henceforth and forever.
Sovereign state are Kabbalistic words, not understood by the disciple of liberty.
I reread those last two lines there. That's Gaines versus Buford again. Another really good one. I also note with alarm the seditious doctrine sometimes embraced by our majority that even our Declaration of Rights is itself trumped by the exercise of the states, the government's police power, a power with which a majority of my colleagues seems to believe with their newfound wisdom has no limits whatsoever.
Not my queen.
Right, they have a gun, so, you know, you can see where I'm going with that. Fundamentally, when a majority of our court claims that our state legislature has plenary power to enact laws, except as limited by our state and federal constitutions, it departs from the founding principle that governments may legitimately perform only those activities which are delegated by the sovereign people. Moreover, the majority seems most willing to even subordinate express constitutional exceptions enumerated in the Declaration of Rights and elsewhere to the omnipotent power of the plenary state government. I fear for our republic each step the majority takes toward achieving its counter-revolutionary premise. One cries outrage when the majority purports to recognize a fundamental principle of our system of government, which is in reality absolutely antithetical to those true principles of our republic, which are indeed fundamental. More fundamentally, the brilliance of our system is in its devotion to the sovereignty of the people and the rule that those who must bear the law may make the law. And that's out of Washington State Farm Bureau Federation versus Gregor. And again, this is speaking in general. You know, if someone tries to tell you that doesn't apply in California, it's from Washington. I already explained that. So, the government is an agent, and within the sphere of agency, a perfect representatives. But outside of that, it is a lawless usurpation. The constitution of the state is the limit of the authority of its government, and both government and states are subject to supremacy of the Constitution of the United States and of the laws made in pursuance thereof. So that, while it is true in respect to the government of a state, as was said in Langford v. United States, in U.S. Supreme Court, that the maxim that the king can do no wrong has no place in our system of government. Yet it is also true in respect to the state itself that whatever wrong is attempted in its name is imputable to its government and not to the state.
The maxim that the king can do no wrong has no place in our government.
You see why I keep subbing in the word government for the word state? For, as it can speak and act only by law, whatever it does say and do must be lawful. That which therefore is unlawful because made so by the supreme law, the Constitution of the United States, is not the word or deed of the state, but is the mere wrong and trespass of those individual persons who falsely speak and act in its name. It was upon the ground of this distinction, important distinction, that the court proceeded in the case of Texas v. White, when it adjudged that the acts of secession, which constituted the Civil War of 1861, were the unlawful acts of usurping state governments, and not the acts of the states themselves, inasmuch the Constitution in all its provisions looks to an indestructible union comprised of indestructible states. And that consequently the war itself was not a war between the states, nor a war of the United States against states, but a war of the United States against unlawful and usurping government representatives, not the states, but a rebellion against the United States. This is in substance what was said by Chief Justice Chase, delivering the opinion of the court in Thorington v. Smith, when he declared, speaking of the Confederate government, that it was regarded as simply the military representative of the insurrection against the authority of the United States. The same distinction was declared and enforced in Williams v. Bruffy and in Horn v. Lockhart, both of which were referred to and approved by Keith v. Clark. This distinction is essential to the idea of constitutional government. To deny it or blot it out obliterates the line of demarcation that separates constitutional government from absolutism, free government based on the sovereignty of the people, from that despotism. Whether of the one or the many, which enables the agent of the state to declare and decree that he is the state, to say el etat siest moi. Of what avail are written constitutions whose bills of right for the security of individual liberty have been written too often with the blood of martyrs shed upon the battlefield and the scaffold, if their limitations and restraints upon power may be overpassed with impunity by the very agencies created and appointed to guard, defend, and enforce them, and that to which sacred authority, and that too with the sacred authority of law, not only compelling obedience but entitled to respect? Now again, as I said, when you go into court, be respectful, but you know what this is. And how else can these principles of individual liberty and right be maintained if, when violated, the judicial tribunals are forbidden to visit penalties upon individual offenders who are the instruments of wrong, whenever they impose the shield of the state? This doctrine is not to be tolerated, the doctrine. The whole frame and scheme of the political institutions of this country, state and federal, protest against it.
Not my queen.
Their continued existence is not compatible with it. It is the doctrine of absolutism, pure, simple, and naked, and of communism, which is its twin, the double progeny of the same evil birth. In no other way can the supremacy of that constitution be maintained. It creates a government in fact as well as in name, because its constitution is the supreme law of the land. Anything in the constitution or laws of any state to the contrary notwithstanding, and its authority is enforced by its power to regulate and govern the conduct of individuals, even where its prohibitions are laid upon the states only upon the states themselves. And again, the mandate of the state affords no justification for the invasion of rights secured by the Constitution of the United States. Otherwise, that Constitution would not be the supreme law of the land.
The law does not protect he who slumbers on his rights. Maxim of law.
So, once again, as you can see, when they violate the Constitution, which is the supreme law of the land, they are breaking the law. They are committing a crime. You know, these entities, you know, they charge someone with disorderly conduct, what they call the DA's best friend, because they can convict anyone of disorderly conduct. There's no element of intent. So you don't have to have been even intended to disturb someone, and they can convict you of that and get you in their system. Yet, and they want to start studying you, saying, well, let's look at your criminogenic profile because you disturbed somebody, while they work for people who are some of the most insidious criminals. And again, let's just keep it real here. Not everyone in government is corrupt, okay? Many of them are, not everyone is. So remember that, because sometimes people inside will help you, can help you, and we kind of rely on that because, you know, when you're filing these papers, if everyone is against you, you're not going to win. Sovereign power isn't delegated to the government at large. It is given to specific public officials to exercise in particular ways. The original and supreme will organizes the government and assigns to different departments their respective powers. The people are sovereign and are therefore the authors and owners of the law. Thus, for example, in Banks and Bro v. W. Pub Co., the court justified the rule on the grounds that each citizen is a ruler. The word citizen there is a little, edgy, but a lawmaker, and as such has the right of access to the laws he joins in making and to any official interpretation thereof.
All sentient beings have inherent sovereignty.
The same power vested in Parliament and King in England is here vested in the people, who are fully as much sovereign here as Parliament and King there. So, I hope you have a strong mind, because all the facts are right here in front of you in black and white, but they're going to gaslight you just like they do about everything else. So be prepared. A sovereign power cannot be surrendered. And then we go into a little bit of what they're up to. If these sections are unconstitutional, the law is void, and an offense created by them is not a crime, and a conviction under them cannot be a legal cause of imprisonment. Okay? Now, they do it all day long, every single day. For no court can acquire a jurisdiction to try a person for acts which are made criminal only by an unconstitutional law. I have a lot more sites on this, but I'm sticking to the sovereignty sites tonight. These are civil rights and inalienable, and of which he cannot be deprived by the people of the state. But a political right stands upon a very different principle. It is a political privilege or grant that may be extended or recalled at the will of the sovereign power. Under our system of government, the people are sovereign. See U.S. Constitution Preamble, we the people establish the Constitution, etc. That all power is vested in and consequently derived from the people, that magistrates are their trustees and servants, and at all times amenable to them. Judges who serve the sovereign are vested with the power of judicial review in individual cases to determine whether a legislative enactment conforms to the Constitution. See Marbury versus Madison. This counter-majoritarian power should be exercised with caution and circumspection. Sovereignty lies with the people, not a king. See the Federalist number 22, etc. Each citizen is a ruler, a lawmaker, and as such has a right of access to the laws he joins in making into an official interpretation thereof. I read that already. The states cannot, in the exercise of control over local laws and practice, vest state courts with power to violate the supreme law of the land. Besides, the prince having all the executive powers, the judgment of the courts would in fact be only monitory, not mandatory to him, and a capacity to be advised is a distinct thing from a capacity to be sued. The same feudal ideas run through all their jurisprudence and constantly remind us of the distinction between the prince and the subject. No such ideas obtain here. At the Revolution, the sovereignty devolved on the people, and they are truly the sovereigns of the country, but they are sovereigns without subjects. And it even goes so far as to say, about African slaves, and have none to govern but themselves. This is pre-14th Amendment, I want to say, when they made that statement. That's just an extended version of Chisholm versus Georgia, but...
In a republic, the people are sovereign, not subjects.
Okay, this is the Marion versus Jicarilla Apache tribe. To presume that a sovereign forever waives the right to exercise one of its powers unless it expressly reserves the right to exercise that power in a commercial contract turns the concept of sovereignty on its head. I basically cited it word for word, but that's the reservation of sovereignty. Your driver's license, all that crap. Not only that, but if you entered into a contract with someone and they knew at the time you entered into the contract something that you didn't know and you would have objected to, and on all law, international and otherwise, that makes the contract null and void.
Equitable remedy has its efficacy.
And here again, the Wisconsin appeals court quotes almost word for word what a court of record is. The common law, and the magistrate is independent of the tribunal. Let's see. Yeah, right there. Independent of the tribunal, or the magistrate, rather, and according to the common law. Proceeding according to the common law. So a little bit about inferior courts and superior courts. Like I said, an inferior court is one proceeding according to statute, special or limited jurisdiction, whereas a common law court is a court of general jurisdiction, a superior court. I'll get better sites for that in another video. And here you see in the NOLO's Plain English Law Dictionary, magistrate is what they call a judge. Since the people are sovereign and since the magistrates are servants of the people, the magistrates can do no wrong and the people have a fundamental right to criticize them and to expose their inefficiency and corruption so that they may be displaced. And again, we'll say a justice court is an inferior court of limited jurisdiction, not proceeding according to the course of the common law. And although a justice is required to keep a docket and enter his proceedings, this does not constitute his court a court of record. In this country, it is universally acknowledged and insisted upon that the people are the original source and fountain of all civil and political power, that neither the whole government nor any department thereof possesses any inherent power, that the people are sovereign, and the different departments of government are simply agencies through which the people exercise that sovereignty, and that all the power can be exercised by any department of the government is merely delegated power which it derives from the people.
Lansing versus Smith. The sovereignty of the people.
That political sovereignty in its true sense exists only with the people, and that government is founded on their sole authority and subject to be altered, reformed, or abolished only by them is a political axiom upon which all the American governments have been based and is expressly asserted in the Bill of Rights. I actually found this site because the definition of treason is an act against the political sovereignty. Now you see that's an act against the people. It's a little aside there, a little footnote there. And again, it is that a sovereign, like any other principal, cannot authorize its agent to violate the law, so that when he does so, he cannot be acting for the sovereign. And this is the quote from the Wisconsin statutes. The entire section about courts, record, judges, attorneys, etc., and clerks, chapter 757, is entitled General Provisions Concerning Courts of Record. So all the courts are supposed to be courts of record, which means common law courts where the people are making decisions, not the magistrates. They've got everyone fooled into thinking that they make all the rules. It's sedition, it's subversion and treason, infiltration. The court seems to assume that sovereignty in this country belongs to the state and federal governments, much as it once belonged to the King of England. But as Chief Justice Marshall has explained, the government of the Union is emphatically and truly a government of the people, and all sovereignty emanates from them. Now, as far as the common law, as has been aptly said, is a system of principles and not a collection of arbitrary rules. The common law claims to be the perfection of reason, and it is one of its maxims that where the reason ceases, the law ceases, which kind of touches into the idea of how statutes are, if there's no statute, then there's no remedy. If someone's injured you, it's clearly an injury. If there's no statute, there's no remedy in the statutory system. Likewise, if a statute is basically just, a technicality, but they're going to charge you with the crime, even though no one was injured, that's the other side of that coin. There's a good quote here about common law too. Besides, all laws, as well as all contracts, may be controlled in their operation and effect by general fundamental maxims of the common law. No one shall be permitted to profit by his own fraud, or to take advantage of his own wrong, or to found any claim upon his own iniquity, or to acquire property by his own crime. These maxims are dictated by public policy, have their foundation in universal law, administered in all civilized countries, and have nowhere been superseded by statutes. So the law does not entertain trifles, a maxim of law, and this is an interesting point here. The law does not protect he who slumbers on his rights. So they say ignorance is no excuse for the law. Ignorance of the law is no excuse. Well, that goes for them too, but that goes for us. If people are too busy to learn this stuff, and I get it, the guy is so overworked, but this is a huge key. This is a major matrix red pill situation. The power which is derived cannot be greater than that from which it is derived. From the 15th century English common law to Larson and beyond, courts have never held that prohibited conduct can be shielded by sovereign immunity. That rule makes good sense, since a principal cannot authorize unlawful conduct. Such conduct is of necessity ultra vires, as I said earlier. And as quickly as goes into challenges to jurisdiction, No officer can acquire a jurisdiction by deciding that he has it. In all such cases, every officer, whether judicial or ministerial, decides at his peril. So when you challenge jurisdiction, they have to prove it on the record. That's another video. This is a good point here. In common usage, the term person does not include the sovereign. Statutes employing the word are ordinarily construed to exclude it. So read all the statutes and it talks about a person. They're talking about a subject. Now the word person is flexible, but in those cases you can see the site right there. And this is an interesting one. This is not necessary to execute these procedures, but it's a good one. You know, the all caps name. You ever heard the all caps name is your straw man? It's a corporation, it's a trust. Well, here's a cite for you. These findings clearly indicate a determination by the trial court that Michael DeRocha, with the name spelled thusly, and all caps Michael DeRocha are separate entities. Now, I'm going to tell you something right now. There are many websites out there that that teach this type of thing that have incorrect sites. They have sites that you can't find. They're either lost because they have blocked them or they were incorrect to begin with. I'm not sure which, but always check your sites. If you're found citing false sites, it's going to work to your detriment. And then here's Winding versus Freer in Bolins out of Wisconsin. Every taxpayer is a Sesticade trust. Okay? Are you a trust? Or are you one of the people? Are you a living, breathing being, you know? Exactly. The power of the people of the states to make and alter their laws at pleasure is the greatest security for liberty and justice, this court has said in Hurtado versus California. That's Twining versus New Jersey, U.S. Supreme Court. And the people of the several states are absolutely and unconditionally sovereign within their respective territories.
The sovereignty of the people.
That's Ohio Life Insurance and Trust versus DeBolt, U.S. Supreme Court. It is an established principle of jurisprudence that the sovereign cannot be sued in its own courts without its consent. Because sovereignty is vested in the people of the state, moreover, immunity does not equally attach to every act by every governmental entity or political subdivision. As a starting point, the state generally enjoys immunity for its lawful function, which are on behalf of the people. But for example, when a government officer acts ultra vires, immunity does not protect his acts. That is because acts done without legal authority are not done as a branch of the state. By definition, they fail to derive their authority from the root of the state's immunity, the sovereign will. So, talking about common law, it's not all written. So we go into a little bit of unwritten law here, a little bit of Magna Carta due process, but I've covered the subject of sovereignty here. And again, these are all just cites. You decree the cites because they're good material, but you're actually decreeing it. As I showed you, the very first cite you saw, the very definition of sovereignty is that the decree of the sovereign makes law. So you must follow the procedure. This is the video about what sovereignty actually is, and a few other little things here I threw in, and I'm going to wrap it up. I'll just real quick, Black's Law Dictionary, inferior court. Special or limited or statutory jurisdiction. Okay, I only read an excerpt of it, but this is a major point. And when you open up your court, it is a superior court of general jurisdiction proceeding according to the course of the common law. And when they come at you with some unconstitutional crap, you counterclaim against them. You state you're one of the people in a court of record, and you complain that they exceeded their jurisdiction. Don't say they violated your rights, because apparently they're not even under obligation not to do that. The wording is they exceeded their jurisdiction. And an inferior court of special or limited jurisdiction is always open to collateral inquiry, a collateral attack, especially by a superior court, one proceeding according to the course of the common law, okay, which is your court. So a couple more sites about that. I'll make a video about that specifically because you only have so much attention span for this. I hope you have more than a little bit because you're going to have to study a bit. It doesn't take a 4-year law degree, but you're going to have to study a little bit and study some examples. So you know what we're up against, and this is the basis of all their crap. People wonder how they sit all day long and they watch them just wipe their ass with the Constitution. This is how they do it. They're presuming you're a subject of the sovereignty, not one of the people. Okay? So, thank you for watching this video. Please like, share, and subscribe, because people need to find out about this. And check out the website. I have examples on there. There's also examples on a site called 1215.org. That's the year the Magna Carta was written. There are more simple examples on that website of counterclaims, of habeas corpus, ad subjudiendums, of civil cases where this type of action is used. So, yeah, thanks for watching. Have a good night. Have a good day or night, wherever you are.
Not my queen.
In a republic, the people are sovereign. Look it up.
All sentient beings have inherent sovereignty.
Coconut. Coconut.
Sovereign state are Kabbalistic words not understood by the disciple of liberty.
Not my queen.
In a republic, the people are sovereign, not subjects.
The despotic, seditious doctrine is incompatible with our republic and cannot be tolerated.
Unlawful acts are not the word or deed of the state.
Not my queen.
The maxim that the king can do no wrong has no place in our government.
The law does not protect he who slumbers on his rights. Maxim of law.
Poindexter versus Greenhow. Not today, Your Excellency.
Queen, Taramis.
Not my queen. Not today, Your Excellency.